The CEO's smirk died the moment Judge Coulter read Clause 7. The fired employee he'd dismissed 3 months ago was about to own his $40 billion empire. Marcus Hale had built Vanguard Technologies from a garage startup into one of the most valuable companies in the world. 23 years, 18-hour days, sacrifices no one saw, decisions no one questioned. He had engineered buyouts, absorbed competitors, and expanded into 12 countries. His face had appeared on magazine covers. His keynotes drew tens of thousands. Analysts hung on his quarterly earnings calls. Investors spoke his name with reverence. He was the company. Everyone knew it. Everyone except Eleanor Marsh. Eleanor had been Vanguard's chief legal counsel for 19 years. She had drafted contracts when the company was still operating out of rented office space with stained carpet and a single conference room that doubled as a storage closet. She had negotiated terms when banks wouldn't return Marcus's calls, when vendors demanded payment up front, when the future was measured in weeks rather than decades. She had worked weekends, holidays, birthdays. She had missed her daughter's college graduation to close a merger. She had postponed surgeries to attend board meetings. She never demanded recognition. She simply did the work. She remembered the early days with perfect clarity. The cramped office with flickering fluorescent lights that gave everyone headaches by 3 in the afternoon. The printer that jammed every third page and left black streaks across important contracts. The coffee maker that only worked if you kicked it twice. Marcus, pacing in front of a whiteboard covered in projections that never quite added up. His shirt wrinkled, his hair uncombed, his eyes wild with exhaustion and hope. Back then, they were partners in survival. He had the vision, she had the structure. He dreamed in possibilities. She translated those dreams into legal frameworks that could withstand scrutiny. Together, they kept the company breathing when it wanted to die. But somewhere along the way, as Vanguard grew from 10 employees to 10,000, as the office moved from a converted warehouse to a gleaming tower downtown, as the stock price climbed and the press coverage intensified, the dynamic shifted. Marcus's office moved to the top floor with floor-to-ceiling windows overlooking the city. Eleanor's stayed on the 3rd floor, windowless, tucked between human resources and accounting. Board meetings became exclusive. Strategy sessions happened without her. Investor dinners took place at restaurants she wasn't invited to. She told herself it was natural. Growth required hierarchy. Organizations needed structure. She was still valued, still essential, still part of the core team that made decisions. She believed that until 3 months ago. Marcus had called her into his office on a Tuesday morning in September. She'd brought the quarterly compliance reports, assuming it was routine, the kind of meeting they'd had 100 times before. Review the filings, discuss any regulatory changes, confirm everything was in order. His assistant had smiled at her on the way in, a tight, uncomfortable smile that didn't reach her eyes. Eleanor should have noticed that. Marcus sat behind his desk, a slab of reclaimed wood that cost more than Eleanor's annual salary. Behind him, the city spread out in miniature, buildings like toy blocks, traffic like blood cells moving through arteries. He was typing something on his laptop. He didn't look up when she entered. "Eleanor," he'd said, still focused on the screen, "we're restructuring, bringing in new leadership. Younger voices, fresh perspectives. I'm sure you understand." The words landed like a stone in still water, calm on the surface. Ripples spreading outward. She had stood there, holding the leather folder she'd carried for 2 decades, the same one she'd bought when Vanguard landed its first major contract. "I helped build this company, Marcus. And you've been compensated well for it." His tone was flat. Transactional. The same tone he used with vendors who disappointed him, with employees who underperformed, with problems that needed solving. "It's not about money." He finally looked up. His face was smooth, detached, the expression of someone who had already made a decision and was simply following through with the necessary unpleasantness. "Then what is it about?" She had looked at him for a long moment, studied the face she'd seen transform over 2 decades, the young, desperate entrepreneur who had begged her to take a chance on an unproven company, the focused CEO who had navigated impossible odds, the polished executive who now appeared on business shows and gave TED Talks about innovation and leadership. She set the folder on his desk. "Integrity." Marcus's expression didn't change. He glanced at the folder, then back at his screen. "I'll have HR send you the severance details. It's generous. More than generous, actually. 24 months salary. Full benefits continuation. Stock options vest immediately. You'll be fine." "I'm not worried about being fine." "Then we have nothing more to discuss." Eleanor walked out of that office and didn't look back. She took the elevator down to the 3rd floor. She packed her desk in silence while colleagues avoided eye contact. She carried the single cardboard box to her car and drove home in the middle of the afternoon, the sun harsh and unforgiving through the windshield. But she also didn't throw away the single document she'd kept in a locked drawer at home for 21 years. A document both of them had signed. A document she'd never mentioned. A document that changed everything. That night, she sat at her kitchen table and read it again. Every word, every clause, every signature, the notary stamp, the date, the terms. She had drafted hundreds of contracts in her career, thousands maybe, but this one was different. This one was personal. This one was true. 2 weeks later, she filed a civil claim, not for wrongful termination, not for discrimination or age bias or breach of contract. She claimed ownership. 20% of Vanguard Technologies, based on a single document signed in the company's 2nd year of operation. When the filing hit the news, Marcus's legal team had laughed. His board of directors had dismissed it in a conference call that lasted less than 10 minutes. His PR firm had drafted carefully worded statements about frivolous lawsuits and the importance of protecting innovators from opportunistic claims by disgruntled former employees seeking unearned windfalls. But Eleanor didn't withdraw. She didn't negotiate. She didn't hire a high-profile attorney or launch a media campaign. She showed up to the preliminary hearings alone, carrying the same leather folder, and requested a full trial. The judge had granted it. The courtroom was smaller than Marcus had expected. He'd imagined something grand, something cinematic, marble columns and vaulted ceilings and a gallery packed with reporters. Instead, it was practical. Wood-paneled walls that had seen decades of disputes, fluorescent lighting that buzzed faintly, uncomfortable chairs that squeaked, a courtroom that processed dozens of civil cases every month, where billion-dollar companies fought over contracts and equity and the fine print that separated partners from employees. Judge Marianne Coulter sat at the bench reviewing documents before the proceedings began. She was in her early 60s, gray hair pulled back in a simple knot, reading glasses perched on her nose. She had a reputation for thoroughness, for patience with complex cases, for intolerance of theatrics. Marcus sat at the defendant's table with his legal team. Garrett Finch, his lead attorney, shuffled papers and whispered notes to his associates. Garrett was a partner at Morrison & Gray, one of the most prestigious corporate law firms in the country. He had defended Fortune 500 companies in landmark cases. He had won 90% of his trials. He billed $700 an hour and was worth every penny. Across the aisle, Eleanor sat alone. No legal team, no assistants, no stack of expensive briefcases. Just her, the leather folder, and a yellow legal pad with handwritten notes. Judge Coulter looked up. "This is a civil dispute regarding equity ownership in Vanguard Technologies," she said, her voice flat and procedural. "Ms. Marsh, You claim entitlement to 20% of company shares based on a founding agreement executed 21 years ago. Mr. Hale, your position is that no such agreement exists in any legally binding form, or, if it does, that it has been superseded by subsequent corporate filings, employment agreements, and shareholder resolutions. Is that accurate? Garrett stood, buttoning his jacket. Correct, Your Honor. We believe this claim lacks legal foundation and fundamentally misrepresents the nature of Ms. Marsh's employment relationship with Vanguard Technologies. Judge Coulter looked at Eleanor. Ms. Marsh, are you representing yourself in this matter? Eleanor stood. She looked small in the oversized courtroom chair. Her cardigan was plain. Her shoes were practical, but her hands were steady and her voice was clear. Yes, Your Honor. Do you have formal legal training? I was chief legal counsel for Vanguard Technologies for 19 years. That's not what I asked. I have a Juris Doctor from State University School of Law. I passed the bar examination in 1998. I've drafted or reviewed over 4,000 corporate contracts, merger agreements, and equity distribution documents. I've negotiated settlements in 17 major civil disputes and provided legal counsel on transactions totaling over $60 billion. Judge Coulter nodded slowly. I see. And you've chosen to represent yourself? Yes, Your Honor. Very well. Proceed with your opening statement. Eleanor's opening was brief. She didn't appeal to emotion. She didn't tell personal stories about sacrifice or betrayal. She didn't paint Marcus as a villain or herself as a victim. She simply described the document and the circumstances that created it. In the second year of Vanguard's operation, she said, her voice calm and measured, the company was on the verge of complete collapse. Early investors had pulled their funding after disappointing product tests. Creditors were circling. Vendors had stopped extending credit. The company had approximately 72 hours before forced bankruptcy. Mr. Hale needed capital, legal expertise, and time. I provided all three. I personally loaned the company $50,000 from my savings. I restructured every vendor contract to extend payment terms. I negotiated directly with creditors to defer collections. I worked around the clock to keep the company alive. She paused, letting the words settle. In exchange for these efforts and for my agreement to defer my salary for 6 months, we drafted and signed an equity sharing agreement. That document still exists. It was notarized. It was signed by both parties. It was never nullified. It was never replaced. It was never contested. Under its clear and unambiguous terms, I am entitled to 20% ownership of Vanguard Technologies. She sat down. Marcus leaned toward Garrett and whispered something. Garrett's mouth curved into a slight smirk. He wrote a note on his legal pad and underlined it twice. When it was his turn, Garrett stood slowly, taking his time. He straightened his tie. He walked to the center of the courtroom with the confidence of someone who had performed this ritual hundreds of times and knew exactly how it would end. Your Honor, let me be absolutely clear about what this case actually involves. Ms. Marsh was a valued employee. She was well compensated throughout her tenure. She received competitive salary, comprehensive benefits, performance bonuses, and stock options that vested over time. But she was an employee. Not a co-founder, not a partner, not an equity stakeholder in any meaningful legal sense. He gestured toward Eleanor with a slight, dismissive wave. The document she refers to, if it even exists in the form she claims, was a draft, a proposal, an informal arrangement discussed during a moment of crisis, but never properly executed under state corporate law. It was never filed with the Secretary of State. It was never incorporated into the company's articles of incorporation. It was never referenced in any subsequent shareholder agreement, board resolution, or corporate filing. It has no legal standing whatsoever. He paused for effect. What we have here is a former employee attempting to rewrite history, to claim retroactive credit and compensation for work she was already paid to do. To capitalize on the success of a company built by Mr. Hale's vision, leadership, and relentless dedication. This case should be dismissed immediately. He sat. Marcus didn't look at Eleanor. He stared straight ahead, fingers steepled beneath his chin, expression unreadable, the picture of calm certainty. Judge Coulter made a note. "We'll proceed with witness testimony. Ms. Marsh, call your first witness." Eleanor stood. "I call myself, Your Honor." A murmur rippled through the courtroom. Judge Coulter raised an eyebrow but nodded. "Proceed." Eleanor took the stand. She was sworn in. She sat in the witness chair and looked directly at the judge. On June 12th, 21 years ago, Marcus Hale called me at 11:30 at night. I was working at Spencer & Ross, a mid-sized corporate law firm. I'd been there for 3 years. I was on track for junior partner. I had a stable career, benefits, and a clear future. She spoke without notes. Marcus told me Vanguard was finished. He'd run out of options. The creditors were filing claims. He was going to lose everything. He asked if I would meet him at the office. Judge Coulter listened without expression. I went. We talked until almost 3 in the morning. He showed me the books, the debt, the contracts, the vendor agreements. It was worse than he'd described. The company wasn't just in trouble. It was dead. Legally, financially, operationally dead. Eleanor's voice remained steady. But I saw something he didn't. A way to restructure the debt. A way to renegotiate terms. A legal pathway that could buy us time. I told him I could save the company, but I couldn't do it as outside counsel. I needed authority, access, trust. She looked at Marcus. He asked what I wanted. I told him the truth. I didn't want a salary increase. I didn't want a title. I wanted partnership. Real partnership. I wanted skin in the game. "And what did Mr. Hale say?" Judge Coulter asked. He said yes. The testimony continued for 3 days. Eleanor walked the court through every detail, the late-night meetings, the frantic calls to creditors, the legal maneuvers that bought Vanguard just enough time to pivot, to secure new funding, to survive. She presented emails, meeting notes, handwritten memos from Marcus thanking her for saving us and referring to her as my partner in this insane venture. She showed wire transfer records proving she'd loaned the company $50,000 from her personal savings. She produced vendor contracts with her signature as the negotiating attorney, dated during the crisis period. Then she presented the document itself. It was entered as Exhibit A, a single page printed on plain white paper, dated June 14th, 21 years ago. The heading was simple and clear. Equity Distribution Agreement, Vanguard Technologies. 2 names. Marcus Hale. Eleanor Marsh. 2 percentages. 80%, 20%. 2 signatures. Both clear. Both dated. Both witnessed by a notary public whose stamp was still perfectly legible. The courtroom went completely quiet. Garrett stood immediately, his chair scraping loudly against the floor. Your Honor, this document was never filed with the Secretary of State. It was never incorporated into the company's articles of incorporation. It was never referenced in any subsequent shareholder agreement, stock issuance, or corporate resolution. Under state corporate law, it has absolutely no binding legal effect. Judge Coulter looked at Eleanor. Ms. Marsh, how do you respond? Eleanor rose slowly. She spoke with the precision of someone who had been preparing for this moment for 2 decades. The document doesn't need to be filed with the state to be valid as a contract between private parties. It's not a corporate charter. It's not articles of incorporation. It's a bilateral equity-sharing agreement executed between 2 individuals who were, at the time, the sole stakeholders in a pre-incorporation entity. Garrett opened his mouth to interrupt, but Eleanor continued. State corporate law is clear on this point. Section 14 of the State Business Corporations Act explicitly allows for private equity agreements executed prior to formal incorporation, provided they meet three requirements. They must be in writing, they must be signed by all parties holding claims to equity, and they must be notarized. She held up the document. This agreement meets all three requirements. It was executed 4 months before Vanguard formally incorporated. At the time of signing, there were only 2 stakeholders. Both signed. Both understood the terms. The agreement is legally enforceable. Garrett's jaw tightened visibly. He glanced at his associates, who were frantically flipping through law books. He looked at Marcus, whose face had gone carefully blank. "Your Honor," Garrett said, recovering his composure, "signed even if the document has some technical validity as a contract, which we dispute. Ms. Marsh's subsequent employment agreements, which she signed annually for 19 years, contain clauses clearly stating that she had no ownership interest in the company. Those agreements supersede any prior arrangement." "Do they?" Eleanor asked quietly. Garrett turned to her. "Excuse me. Do those employment agreements explicitly reference and nullify this equity distribution agreement?" "They state clearly that Miss Marsh was an employee with no ownership interest." "That's not what I asked. Do they explicitly reference this document and declare it void?" Garrett hesitated. "They don't need to. The employment classification itself—" "Mr. Finch," Judge Coulter interrupted, "please answer Ms. Marsh's question. Do the employment agreements explicitly reference and nullify the equity agreement?" Garrett's shoulders tensed. "No, Your Honor. They do not explicitly reference it." "Then we have a potential conflict between 2 sets of documents," Judge Coulter said. "We'll need to examine the employment agreements in detail. Continue, Miss Marsh." Eleanor nodded. "I'd like to call Marcus Hale to the stand." The courtroom stirred. Marcus stood, buttoned his jacket, and walked to the witness stand with the same measured confidence he brought to earnings calls and board meetings. He was sworn in. He sat. He looked directly at Eleanor without emotion. She stood at the plaintiff's table, holding a single sheet of paper. "Mr. Hale, do you remember the night of June 12th, 21 years ago?" "I remember it was a difficult time for the company." "Do you remember calling me at 11:30 at night?" "Vaguely." "Do you remember asking me to come to the office?" "It's possible." "Do you remember telling me the company was about to fail?" Marcus shifted slightly. "We were facing significant challenges." "Mr. Hale, I'm not asking about significant challenges. I'm asking about failure, complete failure, bankruptcy, collapse. Do you remember telling me that?" A pause. "Yes." "Do you remember asking me to help save the company? I may have discussed the situation with you." "You did more than discuss it. You begged me to help. Do you remember that?" Garrett stood. Objection, argumentative. Judge Coulter looked at Eleanor. "Ms. Marsh, please rephrase." Eleanor nodded. "Mr. Hale, do you remember what you said to me when you asked me to join Vanguard full-time?" Marcus's eyes narrowed slightly. "I don't recall the exact words." "Let me refresh your memory." She pulled out a small notebook. It was worn, the cover faded. Her handwriting filled the pages in neat, precise lines. "I've kept a work journal since I graduated law school, a habit from my professors. Document everything, record every significant conversation, every major decision, every promise made." She opened to a marked page. June 13th, 2:47 a.m. After reviewing Vanguard's financial situation with Marcus for over 3 hours, he asked me directly, "Will you join the company full-time?" "Not as counsel, as a partner. I can't pay you what you're worth right now, but if we survive this, you'll own part of what we build. 20%. We'll put it in writing." She looked up. "Do you remember saying that, Mr. Hale?" The courtroom was silent. Marcus stared at her. For the first time since the trial began, his composure cracked. just slightly, a tightening around his eyes, a stiffness in his jaw. I was under extreme stress. I may have said things. You said them, well, then you followed through. The next day, we drafted the equity agreement together. You wrote the percentages by hand. I printed the document. We both signed it. You shook my hand and said, "We're partners now. We're going to build something incredible." Marcus looked away. "Do you remember that handshake, Mr. Hale?" "It was a long time ago." "But you remember it." A pause. "Yes." Eleanor took a breath. "And then I spent the next 3 weeks restructuring every contract, renegotiating every vendor agreement, personally calling creditors to ask for extensions. I worked 90-hour weeks. I slept in the office. I postponed my wedding by 6 months because I couldn't take time off. I did all of this because I believed we were partners, because I believed that document meant something." She held it up again. "Did it mean something, Mr. Hale?" Marcus met her eyes. For a long moment, the two of them simply looked at each other across the courtroom, years of shared history compressed into silence. Finally, Marcus spoke, his voice low. "At the time, yes. It meant something. And now? Now the company is different. The structure is different. Everything is different. But the document hasn't changed. The signatures haven't changed. The promise hasn't changed." Marcus didn't respond. Eleanor sat down. Garrett stood for cross-examination. He spent an hour trying to discredit Eleanor's testimony. He questioned her memory. He challenged her journal entries. He suggested she had fabricated the details to support her claim. But Eleanor answered every question with the same calm precision. She had documentation for everything: emails, contracts, meeting notes, a paper trail that stretched back 2 decades. When Garrett finally sat down, he looked frustrated for the first time since the trial began. Judge Coulter adjourned for the day. The trial resumed the following morning. Both sides presented closing arguments. Garrett's was polished and forceful. He argued that corporate law was clear, that employment classifications superseded informal arrangements, that equity ownership required proper state filings and board approval, that Eleanor had been compensated fairly and had no legal claim to ownership. Eleanor's closing was simpler. "This case isn't about corporate formalities," she said. "It's about a promise. Mr. Hale promised me partnership in exchange for saving his company. I fulfilled my part of that promise. I saved the company. I worked for 21 years to help build it into what it is today. Now I'm asking the court to hold Mr. Hale to his promise." She sat down. Judge Coulter said she would issue a written decision within 2 weeks. Marcus walked out of the courthouse surrounded by his legal team. A black sedan waited at the curb. Reporters shouted questions. Cameras flashed. He ignored all of it, climbed into the car, and disappeared behind tinted windows. Eleanor walked out alone. She stood on the courthouse steps for a moment, looking at the autumn sky. Leaves were beginning to turn. The air smelled like rain. She took the bus home, the same route she'd taken for 19 years when she worked at Vanguard, when she arrived early and left late and never questioned whether she belonged. 12 days later, the decision arrived. Marcus was in a board meeting on the 23rd floor when his assistant knocked softly and handed him an envelope. The room fell silent. He opened it slowly, unfolded the pages, and began to read. His face went still. "Marcus?" one of the board members prompted. He didn't respond immediately. He read the first page, then the second, then the third. Finally, he set the papers down carefully, precisely as if they might detonate. "We lost," he said quietly. The room erupted. Questions overlapped. Board members stood. Lawyers reached for phones. But Marcus just sat there, staring at the decision. Garrett grabbed the document and read aloud, his voice tight. The court finds that the equity distribution agreement dated June 14th is a valid and enforceable contract between Marcus Hale and Eleanor Marsh. The agreement meets all legal requirements under State Business Corporations Act, Section 14. Ms. Marsh is entitled to 20% ownership of Vanguard Technologies, retroactive to the date of signing. Someone swore. Garrett continued reading. Additionally, Ms. Marsh is entitled to 20% of all dividends, stock distributions, and corporate proceeds issued during the term of her claimed ownership, calculated from June 14th of the founding year to the present date. The room exploded again. Someone was shouting about appeals. Someone else was calculating numbers on a laptop. A board member was demanding an emergency shareholder vote. But Garrett held up his hand. There's more. The room quieted. He read slowly, his voice dropping. However, the court also finds that Mr. Hale's management decisions, corporate expansions, and fiduciary actions were made in good faith and within his authority as majority shareholder. Ms. Marsh's ancillary claims of operational misconduct, breach of fiduciary duty, and intentional misrepresentation are denied. Furthermore, the court notes that Ms. Marsh's shares are subject to the company's existing shareholder agreement, including provisions requiring board approval for any sale, transfer, or liquidation of equity. One of the attorneys leaned forward. That's significant. She can't just sell her shares. She can't force a buyout. She's locked into the shareholder agreement like everyone else. Marcus still hadn't moved. Garrett continued. The court further notes that both parties overlooked a critical clause in the original equity agreement during testimony and arguments. The room went silent. Clause 7 of the original agreement reads as follows. In the event of dispute regarding equity distribution, ownership, or corporate governance, both parties agree to submit to binding arbitration or civil court review. However, if the court finds in favor of the claimant's ownership stake, the majority shareholder must offer the claimant a seat on the board of directors within 30 days or forfeit an additional 5% equity to the claimant, bringing the claimant's total ownership to 25%. The room was dead silent. Garrett looked at Marcus. Did you know this clause was in there? Marcus slowly shook his head. I haven't read that document in 20 years. Neither did we. We focused on the ownership percentages. We never examined the dispute resolution clause. Another attorney grabbed the document. So Marcus has to offer her a board seat within 30 days, or she automatically gets another 5%. That's what it says. Can we appeal? Garrett read the final paragraph. The court's decision on the validity and enforceability of the equity agreement is final and binding. No appeal is permitted on this matter. However, parties may separately petition regarding the interpretation or implementation of specific clauses. He set the document down. We could try to argue about Clause 7's interpretation, but it's pretty clear. Offer her a board seat or she gets more equity. Those are the only options. Marcus picked up the decision again. At the bottom of the final page, in Judge Coulter's neat handwriting, was a footnote. He read it silently. This case illustrates the fundamental importance of reading and honoring contracts in their entirety. Both parties signed an agreement that contained protections for fairness, partnership, and equitable dispute resolution. Mr. Hale is reminded that legal agreements are not suggestions. They are binding commitments. Ms. Marsh is reminded that ownership carries responsibilities as well as rights. Both parties are encouraged to move forward with integrity, transparency, and mutual respect. The court hopes this decision serves justice and reinforces the principle that one's word, when documented and signed, must be honored. Marcus set the paper down and looked out the window at the city he'd conquered, at the buildings that bore his company's name, at the skyline he'd helped shape. For the first time in 20 years, he didn't feel like he owned it. 3 weeks later, Eleanor Marsh received a letter. It arrived by courier, not by email or certified mail, but hand-delivered in a cream-colored envelope with Vanguard's embossed logo in the corner. She opened it at her kitchen table. The handwriting was Marcus's. "Eleanor, the court ruled in your favor. You were right, I was wrong. Not just legally, ethically, morally, fundamentally. I've spent the past 3 weeks trying to understand how I let this happen. How I convinced myself that the document we signed didn't matter, that the promise I made wasn't real, that your contributions were adequately compensated by a salary and benefits. The truth is, I remember every detail of that night. I remember how desperate I was, how certain I was that everything I'd built was about to collapse. I remember asking you to save the company, and I remember promising you partnership. Real partnership, in exchange. I also remember the moment I stopped seeing you as a partner. It was about 8 years ago. We just closed the Meridian acquisition. The board threw a celebration dinner. You weren't invited? I noticed. I should have said something. I should have insisted you be there. Instead, I told myself it was just logistics, just an oversight. Just the way things worked in a company that had grown too large for everyone to be included in everything. But it wasn't an oversight. It was a choice. My choice. And I made it again and again, in 1,000 small ways, until I'd completely rewritten our history in my mind. Until I'd convinced myself that I'd built Vanguard alone. I can't undo 20 years of ingratitude and erasure. But I can do this. I'm offering you a seat on the board of directors. Not because Clause 7 requires it, though it does. Not because my lawyers advised it, though they did. I'm offering it because you've earned it. You earned it 21 years ago. You've earned it every day since. If you accept, I'll see you at the next board meeting. We'll have a lot to discuss. We'll probably disagree on many things, but at least we'll be having those disagreements as partners. The way we should have been doing all along. If you don't accept, I'll understand. I'll also respect your decision and ensure your ownership stake is properly documented and honored. You'll receive every dividend, every distribution, every right that comes with being a 20% owner. No more erasure, no more dismissal. I'm also implementing changes at Vanguard. I'm requiring all equity agreements to be reviewed annually. I'm creating a whistleblower system for employees who feel their contributions have been minimized or stolen. I'm establishing clear protocols for how founding agreements are documented and preserved. It won't fix what I did to you, but maybe it will prevent me from doing it to someone else. I'm sorry, Eleanor. I'm deeply, genuinely sorry. Marcus. Eleanor sat with the letter for a long time. Outside, the afternoon light was fading. The kitchen was quiet except for the hum of the refrigerator and the distant sound of traffic. She thought about the courtroom, about the years of silence, about the single document she'd kept in a folder for 2 decades, not because she'd been planning to use it, but because it was true, because it represented something that mattered more than money or recognition. It represented a promise. She picked up a pen and wrote on the back of the envelope. Marcus, I accept the board seat. But know this, I'm not accepting it to make you feel better. I'm accepting it because Vanguard was as much my creation as yours, and I intend to have a voice in what it becomes. I don't want your apology. I want your commitment to do better, to treat people with integrity, to honor your promises. To remember that companies aren't built by CEOs alone. They're built by everyone who believes in the vision and does the work. See you at the board meeting. Eleanor. She mailed it the next morning. 6 months later, Eleanor Marsh attended her first board meeting as a voting member. She arrived early, carrying the same leather folder she'd carried for 2 decades. The boardroom was on the 23rd floor, all glass and chrome and minimalist furniture that cost more than most people's cars. She sat near the window. The city stretched out below, vast and indifferent. Other board members arrived in clusters, talking quietly, eyeing her with curiosity and wariness. When Marcus entered, the room went silent. He walked to his seat at the head of the table. Then he paused, looked at Eleanor, and stood waiting. The rest of the board stood as well. Eleanor nodded once and took her seat. The meeting began. The first hour was routine. Quarterly earnings, revenue projections, market analysis. Eleanor listened carefully, taking notes, absorbing the information she'd been shut out of for years. Then came new business. "We have a proposal for a major acquisition," the CFO said, displaying a presentation on the screen. ClearPath Analytics, mid-sized competitor, strong technology, struggling leadership. We can acquire them for approximately $2 billion and integrate their platform into ours within 18 months. Board members nodded. It was the kind of deal Vanguard did routinely. "Questions?" Marcus asked. Eleanor raised her hand. "What happens to ClearPath's employees?" The CFO blinked. "I'm sorry. They're employees. They're teams. What's the integration plan?" "Standard protocol. We'll evaluate performance, retain key talent, eliminate redundancies." "Eliminate," Eleanor repeated. "Meaning layoffs?" "Well, yes, that's typical in acquisitions of this nature." Eleanor leaned forward. "How many people are we talking about?" The CFO glanced at his notes. Approximately 400 positions would be eliminated. 400 people lose their jobs so we can absorb their technology. That's a somewhat reductive characterization, but yes. Eleanor looked at Marcus. "I'd like to propose an alternative." The room went quiet. "Instead of eliminating 400 jobs, what if we offered retraining, relocation within Vanguard? Use this acquisition as an opportunity to invest in people, not just technology." One of the board members frowned. That would significantly increase integration costs. By how much? The CFO calculated quickly. Approximately $300 million over 2 years. And our projected profit from this acquisition? $700 million annually after full integration. Eleanor nodded. "So we'd still be profitable. We'd just be profitable while also honoring the people who built the company we're buying." Another board member spoke up. "Ms. Marsh, with respect, this isn't how acquisitions work. The market expects efficiency. Shareholders expect returns. Shareholders also expect companies that don't treat people as disposable assets, and the market rewards companies with strong employment practices and low turnover." She looked around the table. "I'm not suggesting we run a charity. I'm suggesting we run a company with integrity. The kind of company I thought we were building 21 years ago." Silence. Marcus leaned back in his chair, studying her. "I'd like to hear more about this proposal," he said quietly. "Eleanor, can you draft a detailed plan for the next meeting?" She met his eyes. "Yes." "Then let's table this decision until we've reviewed both approaches. All in favor?" The board voted unanimously. The meeting continued for another 2 hours. Eleanor asked questions. She challenged assumptions. She pushed for transparency in areas where Vanguard had historically been opaque. She voted against one proposal entirely, forcing it back for revision. When it finally ended, board members filed out quickly. Eleanor stayed, organizing her notes. Marcus remained as well. After everyone else had gone, he spoke. "You're going to be difficult, aren't you?" Eleanor smiled faintly. "I'm going to be honest. If that's difficult for you, that's your problem." He almost laughed. "Almost. The board isn't used to being challenged. Then they need the practice." Marcus walked to the window, hands in his pockets, looking out at the city. "I meant what I wrote in that letter, about being sorry, about doing better." "I know. Do you forgive me?" Eleanor considered the question. She stood and walked to join him at the window. "I don't know yet. Forgiveness takes time. Trust takes even longer. But I'm willing to see if you mean what you say." Marcus nodded slowly. That's fair. They stood there in silence for a moment, two people who had built something together, and then spent 20 years pretending they hadn't. Thank you, Marcus said finally, for not walking away, for fighting for what was right. Eleanor looked at him. I didn't fight for myself, Marcus. I fought for the truth, and I fought for every person who's ever had their contributions erased or their promises broken. If this case does nothing else, I hope it reminds people that words matter. Contracts matter. Integrity matters. She gathered her things and walked toward the door. Then she paused and looked back. Next time you make a promise, honor it from the start. It'll save everyone a lot of trouble. Marcus smiled sadly. I will. Eleanor left. The boardroom was empty except for him and the low hum of the city beyond the glass. Marcus looked at the table, at the vacant chairs, at the place where Eleanor had sat and asked difficult questions and refused to accept easy answers. For the first time in years, he felt something close to hope. Maybe it wasn't too late to build something worth keeping. 18 months later, Vanguard Technologies completed the Clear Path acquisition under a revised integration plan. 400 jobs were preserved through retraining programs and internal transfers. Employee satisfaction scores rose. Turnover decreased. The market rewarded the approach. Stock prices climbed. Eleanor Marsh attended every board meeting. She challenged every questionable decision. She pushed for transparency, accountability, and ethical practices in every corner of the company. Some board members resented her. Some respected her. All of them listened when she spoke. And in a quiet office on the 3rd floor, Eleanor kept a leather folder in her desk drawer. Inside was the original equity agreement, preserved and protected. She never needed to use it again, but she kept it as a reminder. Words on paper, signatures and dates. Promises made and promises kept. The foundation of everything worth building.